recording cutting, so let's go to section 5 again. So section 5 is am I going to get through this? I don't know. Ethical considerations in identifying in reports of cases a defendant's relative or friend. So part 5.1, it says that the clause 9 excuse me. Clause 9 of the Editor's Code of Practice warns that relatives or friends of defendants should not usually be identified unless such a person is genuinely relevant to the story. And you should also see adjudications summarised in Children, Other Relatives and Friends of Crime Suspects or Defendants in the additional material for Chapter 4 on mcnays.com, and check McNays' websites for updates as regards to ipso adjudications on when a relative or friend is genuinely relevant. I've just put a link so you have to do your own work now. The defendant's relative, including the child or friend who is in that case is a witness, victim or alleged victim, or is otherwise mentioned in proceedings, is genuinely relevant. And that's discussed in additional material case examples. That ipso has ruled that a report which included the fact that the defendant's girlfriend, who was an adult, accompanied him to the court hearing and was in the public gallery, naming her, and which did not otherwise focus on her, did not breach the code because her apparent act of support for him made her genuinely relevant. That was Mitchell versus Daily Record, adjudication issued in 2016. Footnote: obviously, candidates are expected to spot an exam question scenario if a defendant's relative, including the child or friend, does or could have anonymity in law because of reporting restrictions specified in other parts of this programme. 5.2. That with regards to the defendant's child who is genuinely relevant, the most ethical course may be, if there is to be a reference to the child in the coverage, not to identify him, her by name or image. And also that ipso has ruled that a report which included the name of the defendant's wife and children when quoting from mitigation given for him in court did not breach the code because this mention made them generally relevant, but that ipso, referring to the editor's discretion, welcomed the publication's decision to delete the children's names from the online article. This was a Man versus Wells Online, an adjudication issued in 2017. Over part 6. Almost there. The restrictions on identifying complainants in sexual offences cases, ethical considerations relevant to such identification, and to the identification of child witnesses, child victims in such cases. Restrictions on identifying complainants in human trafficking cases. 6.1. That the Sexual Offences Amendment Act 1992 automatically bans any publication from identifying a person as being a victim, alleged victim, the complainant of a sexual offence. And there we go, that important, automatic. That the scope of these restrictions is that no detail must be published which identifies them in this context during their lifetime, and what is stated by the Act as regards scope to be detail which in particular should not be published if likely to identify such a person in this context. I love the long sentences. So this is the particulars not to be published: their name, address, identity of school, educational establishment they attend, identity of any place of work, any still or moving picture of them, like we've heard before. The danger of jigsaw identification. We should know this one, that one now. Note, as regards to particular offences, candidates should be able to recognise in an exam that the anonymity normally applies in respect of allegations of rape, assault by penetration, other types of sexual activity with a child, including by an adult family member, and including what is termed in older law as incest, sexual assault, trafficking a person for sexual exploitation, including for prostitution, controlling a prostitute for gain, exposure, voyeurism, and meeting or intending to meet a child for sexual grooming, or following sexual grooming. Right. I've highlighted the one that may not be obvious and which featured in the previous exam, which is trafficking a person for sexual exploitation here. This is part of the Modern Slavery Act 2015, which amended Section 1 of the Sexual Offences Act 92 to provide lifelong anonymity for victims of human trafficking offences. McNay's page 114 has more details. We need to know that charges of rape, of assault by penetration, and any other sexual activity with a child under 13 which allegedly involves penetration are indictable only, and that the other sexual offences listed are either way. Also says to see subpart 2.1 of this program, which we've come across. Some notes here as well. Candidates should know that the anonymity normally applies in respect of reports of crimes of court cases involving attempts and alleged attempts to commit sexual offences or allegations of conspiracy, incitement and aiding in respect of such offences, and to reports of any civil case in which a sexual offence is alleged or admitted to have been perpetrated. Note, candidates should know that the Act does not empower a court to ban identification of the accused, but that care may be needed as regards the content of the court report to ensure that identifying the accused does not point to the identity of the victim. Incest cases are especially relevant here. 6.2. That the circumstances in which this anonymity ceases to or does not apply include that such a person can, if aged over 16, sign a written waiver to consent to be identified in a media report of such a crime or court case, and the conditions which need to be honoured to make the consent valid. So, Section 5 of the Act, which specifies the consent must be in writing, the person waiving anonymity must be aged 16 or over, and the consent will not be valid if it is proved that anyone interfered unreasonably with the peace and comfort of the individual with the intention of attaining it. You also need to know that in some circumstances a court may lift this anonymity. One example is where it is satisfied that the anonymity would impose a substantial and unreasonable restriction on media reporting of the trial, and it is in the public interest to remove or relax it. That is only a Crown Court that has the power to do that. The court could also order the restriction to be lifted if it is to induce people likely to be needed as witnesses to come forward, or if the conduct of the applicant's defence at the trial is likely to be substantially prejudiced by the anonymity being in place. But courts are rarely asked to do that. That the anonymity does not apply to a report of a court case when the charges in those proceedings were originally and remain other than the sexual offences alleged by that alleged victim. E.g., such anonymity does not apply to a report of court proceedings in which a person who claimed to have been victim of a sexual offence has been prosecuted in those proceedings in respect of that claim for perjury, wasting police time, or preventing the course of justice. It continues, and that because of the other than definition, the anonymity does not apply to a report of a court case when an allegation that a sexual offence occurred is made in evidence in those proceedings if that allegation was at no stage a charge under sexual offence law in those proceedings and there is no other sexual offence charge in the proceedings, but that ethical considerations still apply as regard to identification of such a person who gives or is mentioned in such evidence. McNay's refers to additional material for Chapter 10 about the Northern Echo case, which has happened in Teesside Magistrates Court down the road. So, we'll read from that. Newspaper breached anonymity after the rape charge was dropped. In 2014, the Northern Echo newspaper admitted breach of the Sexual Offences Amendment Act 1992 in what the district judge which fined it described as a novel case. The Echo had published a woman's surname when reporting the trial of a man accused of physically assaulting her. Earlier in those proceedings, before the trial began, a charge that he raped her had been dropped. During the trial, the defendant's barrister had referred to an alleged rape, which did not end up forming part of the case against his client. The fact that the rape allegation did not proceed led the Echo to believe that it could legally name the woman in a report of the trial because the assault charge was not a sexual offence. The Echo thought it could rely on the defence in Section 1(4) of the 1992 Act. As Chapter 10 of McNay's explains, that section says that an alleged victim of a sexual offence can be identified in an article which consists only of a report of criminal proceedings other than proceedings for the sexual offence. But the woman was very distressed about being identified, understandably so, and the Echo accepted, after subsequent research into the origins of the 1992 Act, that though the wording of the statute was unclear, Parliament had intended that the alleged victim of a sexual offence should retain lifelong anonymity even if the sexual offence charge in the proceedings was dropped or reduced to a lesser non-sexual charge. At Teesside Magistrates Court, a district judge fined the Echo £2,400, ordered it to pay £4,500 in compensation and £2,003 in costs and a £480 victim surcharge. Its barrister, Guy Vassall-Adams, said the newspaper immediately accepted that, ethically, the woman should not have been named, but believed that no law had been broken. He said it was a case of genuinely legal uncertain terrain. I think the key there is ethically. Clearly, he should have done it. 6.3. Ethical considerations as regards identification of children in sex cases. Victims, alleged victims, and witnesses are aged under 16, as expressed in Clause 7 of the Editor's Code of Practice, that breach of the 1992 Act's anonymity for victims, alleged victims, also breach this clause, and that if the Act's anonymity does not apply to a child, it would be extremely rare, in brackets exceptional, for the Code's public interest justifications to override the clause's anonymity provisions. That jigsaw identification could cause an ethical breach of such anonymity. That makes sense. 6.4. Rule 1.8 of the Ofcom Broadcasting Code, protecting the under-18s, Section 1, as regards coverage of sexual offences involving under-18s. That breach of the 1992's Act anonymity also breaches this rule as regards to victims, alleged victims, and breach of the rule breaches the Act's anonymity. That the rule warns that jigsaw identification could cause a breach. 6.5. Ethical considerations as regards identification of complainants in coverage of sexual offence cases, as expressed in Clause 11, victims of sexual assault of the Editor's Code of Practice. That breach of the 1992 Act's anonymity also breaches this clause, and that jigsaw identification could cause an ethical breach of such anonymity. That's the Sexual Offences Amendment Act 1992 automatically bans any publication from identifying a person as being a victim, alleged victim, the complainant of an offence, or human trafficking or exploitation as defined by Section 2 of the Modern Slavery Act 2015. The normal scope of these restrictions is that no detail must be published which identifies such persons in this context during their lifetime, and what is stated in the Act as regards to scope to be detail which is in particular should not be published if likely to identify such a person in this context. So that's the stuff we've covered before: name, address, school, work, picture. Note: as regards particular offences, the candidate should be able to recognise in an exam that such anonymity normally applies in respect of allegations of trafficking a person for exploitation in slavery or forced labour, which could include work in domestic servitude or for sexual exploitation, including prostitution. Now, the anonymity applies in respect of alleged or actual attempts to commit such offences and in respect of allegations of or actual conspiracy, incitement and aiding in respect of such offences, and to reports of or features about any civil case in which such offence is alleged or admitted to have been perpetrated. That such a victim, alleged victim of such a human trafficking offence, can, if aged 16 or over, sign a written waiver to consent to be identified in a media report of a human trafficking for exploitation, and the conditions which need to be honoured to make the consent valid. So that's exactly very similar to the sexual offences one, because that's no surprise because it's linked. That in some circumstances a court may lift this anonymity, and the same before. So we'll go over that. So consent, it must be writing, it must be age over 16. It will not be valid if someone interferes with it, and they may lift it if anonymity poses a substantial and unreasonable restriction on media reporting of the trial, or it's in the public interest to relax. That's the main ones. And another long section, that the anonymity does not apply to report of a court case where the charges in those proceedings were originally and remains other than the trafficking offence alleged by that alleged victim, and that because of the other than definition, the anonymity does not apply to report of a court case where an allegation that such a trafficking offence occurred is made in evidence in those proceedings if that allegation was at no stage a charge under this trafficking law in those proceedings, and there is no other trafficking offence charged in the proceedings, but that applicable considerations still apply as regards to identification of such a person who gives or is mentioned in such evidence. E.g., such anonymity does not apply to report if that person is then found guilty of perjury, wasting police time, or perverting the course of justice. So very similar to the other section that I've just gone through. Excellent. Part 7. Open justice and exceptions. Rights to information from courts and to case material. 7.1. We need to know that the fundamental rule, principle in common